That was the mistake that would follow Gerald Harmon for the rest of his life. In the autumn of 1999, Miriam Osei walked into Whitmore University School of Law carrying two things: a second-hand copy of a constitutional law textbook and a scholarship that had taken her 4 years of top grades to earn. She was 24 years old. She was the first person in her family, a family that had come to America from Ghana with very little, to attend law school. She wore a pressed navy blazer every single day of that first week, not because she had many blazers, but because she had one and she cared deeply about the impression it made. The professor of her constitutional law seminar was Gerald Harmon. He was 51 at the time, and he had the kind of confidence that comes from decades of being the most important person in any room he entered. His book on judicial review sat on the shelves of federal courthouses. His former students sent him cards from Washington. His seminars were considered the best in the program, not necessarily because of what he taught, but because of what it meant to be seen by him. If Gerald Harmon liked you, doors opened. If he did not, they stayed shut. He never liked Miriam. It was not a dramatic dislike. It was quieter than that, and in some ways worse. He simply did not consider her. She was, to him, background, one of many faces in a room full of students who were competing for his attention. The students he favored were loud with their opinions, quick to argue, unafraid to interrupt. They filled the room with energy. Miriam was not that kind of student. She listened carefully. She took precise notes. When she spoke, she was measured and thorough, backing every statement with a source. These were, as she would later realize, exactly the qualities that made her a remarkable lawyer. But in Harmon's seminar, they made her invisible. One afternoon, she raised her hand during a discussion about disparate impact doctrine. She had done the reading 3 times. She had written notes in the margins. She offered her argument slowly and carefully, making sure each sentence connected to the last. Harmon let her speak for about 45 seconds. Then he looked away from her, waved one hand in the air as though brushing away something small, and said to the rest of the class, "Let us hear from someone with an actual theory, not just a page from the textbook." The room went quiet in the way rooms do when something uncomfortable has happened and no one knows quite how to respond. A few students looked at their desks. 1 or 2 smiled nervously. Miriam lowered her hand. She picked up her pen. She wrote something in her notebook, not the argument she had just been cut off from making, but something else, something personal, something she would keep. She did not raise her hand again that semester. This was not because she had nothing to say. She had more to say than almost anyone in that room. It was because she had made a decision, very quietly and very firmly, that she would not waste her words on someone who had already decided they held no value. She would put her energy somewhere it would matter. At the end of the academic year, Miriam applied for a prestigious summer clerkship that Harmon's program offered. It was a well-known opportunity, the kind that set graduates on paths toward federal courts and respected firms. Applications had to be submitted through the program director, which meant Harmon reviewed them. Miriam's record was, by any honest measure, exceptional. She was in the top 5% of her class. She was an editor on the Law Review. She had won the school's moot court competition in the spring, arguing her case before a panel of 3 judges with a confidence and precision that impressed everyone in the room. She submitted her application carefully. She included a handwritten cover note, formal and polite. She waited. The response came back on a single sheet of paper. At the bottom, in Harmon's handwriting, were 2 sentences: "Not a strong enough presence for this role. Recommend she consider careers better suited to her temperament." She did not get the clerkship. She read those 2 sentences several times. Then she folded the paper and put it in the back of her notebook, the same notebook where she had written something private on the day he cut her off in class. She told herself she was keeping it as a reminder. A reminder of what, exactly, she could not yet say. But she kept it. Miriam graduated from Whitmore in 2001. She passed the bar examination on her first attempt, scoring in the top 10% of all candidates that year. She joined a civil rights litigation firm in Atlanta, not the most glamorous path available to her, but the one that felt most honest. The work was hard and the cases were real. She spent her first 3 years doing the kind of legal work that never makes headlines: research, filings, long hours in small offices building arguments from scratch. She was the person who stayed after everyone else had gone home. She was the person who read the entire record when others read the summary. Slowly, steadily, she began to win. By 2006, she had argued before 2 federal circuit courts and earned a reputation among her colleagues for being, as one partner put it, the most prepared person in any room she walks into. By 2008, she had added a 3rd circuit court to that list. She was not famous. She was not on television. She was building something quietly, the way people who are serious about what they do usually build things, one careful step at a time. In 2010, the governor of her state appointed Miriam Osei to the bench. She was 35 years old. She became one of the youngest judges in her district. 5 years after that, she was elevated to the Superior Court, where she would preside over civil and criminal cases with a reputation that lawyers on both sides of any courtroom quietly respected. She was known for 3 things: she prepared thoroughly, she kept emotion out of her rulings, and she had an ability to identify the weakest point of any argument that experienced attorneys described as almost unsettling. Nobody gave her any of this. She built it herself, word by word, case by case, year by year. Meanwhile, Gerald Harmon's life continued on its well-lit path. He published 2 more books. He accepted consulting contracts with private financial firms. He sat on advisory boards. He gave speeches at graduation ceremonies about the importance of integrity and hard work. He collected honorary degrees. He was photographed at dinners with senators. He was, to anyone watching from the outside, a man at the top of a long and successful career. The problem, though Harmon would not learn it was a problem until it was too late, was that not all of what he was doing was as clean as it appeared. In 2018, a federal investigation began looking into financial arrangements between several private consulting firms and members of various state advisory boards. What investigators found, after months of digging through bank records, invoices, and communication logs, was a pattern that pointed directly at Gerald Harmon. Over the course of more than 10 years, Harmon had accepted payments totaling over $1,400,000 from a financial consulting firm he had been publicly advising. At the same time, he had been serving on a state regulatory advisory board, a position that gave him real influence over the very financial policies his private clients had a direct interest in shaping. The payments had been routed through a series of consulting invoices that, on the surface, looked like legitimate business. Beneath the surface, investigators argued, they were something else entirely. The charges brought against him were serious: fraud, breach of fiduciary duty, and misuse of public office. His attorney said the payments were legal consulting fees, properly documented and fully disclosed. Prosecutors said the documentation was constructed to conceal what was really happening. The case was assigned to the Superior Court. The presiding judge was the Honorable Miriam Osei. When Gerald Harmon walked into that courtroom on a Tuesday morning in October 2019, dressed in a dark suit, his silver hair brushed back, his cufflinks polished, and looked toward the bench, he saw her face. He recognized her immediately. He had not thought about her in years. He was not sure, in that first moment, whether she recognized him. She gave no sign either way. She greeted both legal teams, confirmed the case number and the charges, and began the proceedings with the same calm efficiency she brought to every case. She permitted no theatrics. When either side's attorney began to drift from the evidentiary record into emotional territory, she redirected them. When a statement was made without proper legal foundation, she noted it. When the defense attempted to introduce character testimony about Harmon's long career and reputation, she reminded counsel, without raising her voice, that the court was concerned with facts and law, not biography. 12 days of testimony followed. The picture that emerged was detailed, specific, and damaging. Financial records showed payments arriving in Harmon's accounts on dates that aligned, again and again, with decisions made by the advisory board he sat on, decisions that benefited his private clients. Emails retrieved from his consulting firm account showed conversations in which policy outcomes were discussed in language that left little room for alternative interpretation. His attorneys worked hard. They were skilled and they argued their case with force. But the record was what it was. On the 12th day, after the jury had deliberated for 2 full days, the verdict came back, guilty on 2 of 3 counts. Gerald Harmon was convicted of fraud and misuse of public office. The 3rd charge was acquitted on a narrow technical point related to how his advisory role had been formally defined. Judge Osei presided over the sentencing phase several weeks later. Under the guidelines available to her, she had discretion within a defined range. She sentenced Gerald Harmon to 4 years in federal prison, a fine of $900,000, and a permanent prohibition on holding any public advisory position for the remainder of his life. She read the sentence aloud in the same level voice she used for everything else in that courtroom. She did not look at him for any longer than was necessary. When she thanked the jury for their service and closed the session, she did it with the same brisk, professional manner she had maintained from the very first morning. He was escorted out. She gathered her papers. That was that. 2 years later, a journalist writing a long profile on Judge Osei for a legal publication went through the routine work of researching her background. In the course of that research, she found Osei's academic records and noticed she had attended Whitmore. A search of the faculty archive from that period confirmed that Gerald Harmon had been teaching there at the same time. The journalist thought it was worth asking about. She reached out to Judge Osei's office and, through the proper channels, submitted the question: had Judge Osei known Gerald Harmon before presiding over his case? The response came through Osei's clerk. In writing, Judge Osei disclosed all prior professional relationships as required by judicial ethics guidelines before accepting the case assignment. The court's ethics board reviewed those disclosures and determined there was no conflict of interest. The journalist, persistent, managed a brief in-person exchange with the judge at a public legal conference. She asked the same question more directly: did you remember him? There was a pause. Not a long one. Then Judge Osei said, I remember every professor who taught me something. She moved on before the journalist could ask a follow-up. When the profile was published, it included one small detail that the journalist had learned from a law school friend of Osei's, a woman who had known her since those early days at Whitmore. The friend said that Osei had mentioned, once, keeping a particular piece of paper tucked into the back cover of her very first legal notebook. She had never thrown it away. It was a note written in a professor's handwriting, on the bottom of a clerkship application, 2 sentences long. Not a strong enough presence for this role. Recommend she consider careers better suited to her temperament. That detail sat quietly at the end of the profile, without commentary. The journalist did not need to add any. The reader could draw their own conclusions. There is something worth sitting with in a story like this. Miriam Osei did not become a judge in order to find Gerald Harmon. She did not spend 20 years planning this moment. There was no dramatic revenge plotted in secret. She simply kept going, through the difficult early years, through the cases that did not make the news, through the long nights of preparation that no one ever sees. She became excellent at something real, and the world, eventually, recognized it. Gerald Harmon, for his part, had spent 30 years in rooms where his opinion was the only one that counted. He had decided, quickly and without much thought, that a quiet young woman with a second-hand textbook was not worth his time. He moved on and never looked back. He never considered that the people we dismiss do not disappear. They go somewhere we are not watching. They keep working. They keep growing. And sometimes, in the long run of things, they end up exactly where they are supposed to be, while we end up somewhere we never expected. The courtroom does not care who you used to be. It cares only about what the record shows. And Miriam Osei, it turned out, had been keeping very careful records all along.